one.
Oh, yes, oh, yes, oh, yes. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning and welcome to the Tennessee Court of Appeals. First of all, I want to express our appreciation for you agreeing to participate in this oral argument via Zoom. We think it's the best way to be doing things at this point in time. Even though we're doing this by Zoom, I want to remind counsel, and both of you are experienced appellate counsel, that we will be following the same rules and procedures as if we were standing in the courtroom today. By that, I mean each side gets 15 minutes to make its oral argument, and if you're the appellant and you've previously requested rebuttal time, you will receive that rebuttal time. We do not expect any technological problems or any glitches with our transmission today. But if there is, then everybody just sit tight. We'll get it figured out and make sure that no one's rights are prejudiced as a result of this. I also want to remind you that we are live streaming this presentation as well. Before we get started, I want to take a moment and introduce our panel for this morning. We have Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Ms. Angie, do we need to take up anything before the case is called?
No, Your Honor.
All right, you may call the case then.
Pamela Lott versus Veronica Mallett, MD, et al.
All right, we will hear from the appellant.
Yes, this is Mr. Tootin on behalf of the appellant. I'd request 3 minutes rebuttal.
All right, sir, you may proceed.
Your Honor, a lot of the arguments, like I said, has been laid out in the brief. I did do a reply to the appellee's response, so I'll rely heavily on that. But I will point out a few things and highlight a few things that I think is important to discuss today. This is a lawsuit against UTMG as well as Dr. Mallett. This is one of those rare scenarios where Dr. Mallett actually worked for UTMG and was an employee at the time of these allegations and these concerns. The first thing that I want to highlight is, again, it's been spelled out in the brief, but I think it's important to note is that this case, it does have some age on it, and it started off with a different judge, and there was a ruling made as it related to when Pamela Lott, the appellant, realized that Dr. Mallett worked for UTMG. That clearly is a question for the jurors to determine, and that's exactly what the trial court concluded initially. The matter was then dismissed without prejudice and brought back in its opposing counsel's position that because the case was brought back under a refiling, that issue was allowed to be relitigated. Where it's the appellant's position that under res judicata, that issue is decided to the same extent that other issues had previously been decided, that the appellant was not able to go back and litigate. The appellant was not able to go back and bring parties back into the case that was previously dismissed. The appellant was not able to go back and bring causes of action that was previously dismissed based on the rulings of the original court. And it's under that same analysis that once the judge made that ruling, that would stand under the refiling. To the extent
that brings up a question, Mr. Tootin, that I am interested in, and that's this. When the initial lawsuit was filed, I believe it was UTMG was brought in as a additional defendant. At the time that UTMG was brought in, as I understand the pleadings, and I may not have it all correctly, but please correct me if I'm wrong, neither consent was obtained from the defendant, nor was leave of court requested or given. So all that was filed was an amended complaint naming UTMG as a defendant. The rules specifically state how that is to be accomplished. And that was not done here. So as far as UTMG being a party in the first lawsuit, was that ever accomplished?
Yes. And I think the reason it was accomplished, and I don't even think it's a question of much dispute. So let me say this when I say I don't think it's a question of much dispute. I was not one of the original lawyers, but I did not see where there was a motion to amend the complaint. I don't see where leave was from opposing counsel. And I do believe that the record, again, as extensive as it was, it would have had that if it was there. However, when you look at the original record and you look at the rulings the court made, the court clearly allowed the amended complaint to go forward with its authority. And in other words, you need leave of the court, but when the court gives you that permission and allows it to go forward and then makes a ruling that is properly before the court and that there's an issue regarding.
Wait a minute. Was the court ever asked if that was properly before the court?
Now that I don't want to misstate, I don't know, because if they weren't asked, then I would think the issue would be waived based on the fact that the case pursued all the way up until the point of trial and that issue was never raised prior to it being dismissed. So I think the problem that opposing counsel would have if it was never raised would be that they would have waived that argument. If it was raised, then that argument.
How can you waive a argument where no one was ever properly joined?
By participating in the proceeding, because, and Your Honor, to be clear about it, when there's a proceeding naming someone as a defendant, and then that defendant participates in that proceeding, engages in the discovery, all the way up until the point to multiple years later that there's about to be a trial setting, including the fact that the judge ruled that informed consent was the issue between that plaintiff and the defendant. I don't know if years later, and let me be clear when I say I don't know, you're not then able to argue years later that you're not properly before the court, that issue would be waived. To the extent the belief is that the issue was not waived, the court clearly concluded in the orders that the amended petition was properly before the court and that the implied consent issue.
When did the court do that?
When they made the ruling that the implied consent issue was going to be a jury question as it relates to the defendant. That analysis is impossible to occur if the party is not even before the court. There's no jury trial to have with a defendant if the defendant is not before the court. The judge understood those arguments to the extent they were raised. And again, I don't want to misstate it. I believe the issue was raised, but I can't cite to something specifically, so I don't want to overstate something. I believe that was one of the arguments made in one of the transcripts where they said, in addition, Judge, the leave wasn't proper or things of that nature. Again, I don't want to misstate something, so I'll let the record speak to that. But once the court hears that argument, understands that medical records were not provided in a timely manner, and then makes a ruling as the judge, I find this complaint to be proper to go forward, and that informed consent is the issue. That analysis only applies to the amended complaint because that's how the defendant, UTMG, would have been before the court. So once the court has done that, I don't believe that you can argue anything other than the court allowed that amended complaint to go forward. Because if the court was not relying on the amended complaint, then they would not even be referring to or making rulings as it relates to UTMG. Because UTMG,
you're talking about in the first case now.
Yes, absolutely. Because, and that goes to my point, Your Honor, because once it's proper in the first case, and we're going forward under the amended complaint in the first case, then once I do the refiling, there is no issue about whether or not they should have been properly before the court in the first case, because quite frankly, they were concluded to be properly before the court in the first case. So once they were concluded to be properly before the court in the first case, then they're necessarily properly before the court in the second case, assuming that everything else was done correctly, which again, we submit that there was. Also, as it relates to UTMG, I don't believe opposing counsel can get around the discovery rule issue. Not only was the court clear in the first case that it's a question for the jurors to determine when Dr. Mallett would have been discovered as an employee, but in addition to that, as it's been laid out, and I cite to all the documents in my brief, appellate, the plaintiff was not even aware that there was an informed consent form that was altered and doctored and did not have information on it that she signed it, that information was added after the fact. She had no way of knowing that until she actually received that information. And when she actually received that information is when the complaint was then amended to add those extra causes of action. So I don't know how. I believe opposing counsel's argument was that I'm trying to create some type of new law or new argument about an informed consent form, but I would respectfully disagree. I won't even get into the weeds with that, other than I don't believe that's a new law issue. I think that's an informed consent issue. It's a potential issue of whether or not that was a medical battery, because basically the representations is that these were the things that was informed to the plaintiff based on it being wrote on that informed consent form, and it's the plaintiff's contention that stuff was never written on there when I signed the document, and that is absolutely something that would have to have been, that the juries would have to know, and the plaintiff cannot be held responsible for not knowing information they could have never possibly known due to the fact that they were not receiving the records to know this issue. And then lastly, as it relates to Dr. Mallett, again, we've attached the releases. I've made the argument, but I do believe that it was a legally sufficient medical release. At a minimum, it substantially complied as a medical release. I think the record and the facts support that. Dr. Mallett was named. It authorized UTMG to disclose the records to Dr. Mallett. And we know this to be true because Dr. Mallett was listed under the language that stated that this was a medical release authorization to disclose protected health information. So it would make no logical argument to say that Dr. Mallett was not included on a release. In the release, she was actually named. So I just think that's a tough argument to believe. In addition, the language went on to state that I authorize use or disclosure of this information covering treatment, and it explains from the time period. So I think that's extremely clear that that includes Dr. Mallett. I think one of the things the trial court got concerned about or maybe confused about is that the medical release had multiple options in which you could select in which to fulfill your purpose, meaning the medical release was out of abundance of caution, used a lot of language. And there were more than one box you could check or not check to accomplish the same purpose. Based on the boxes checked and the information provided on that release, that was sufficient for Dr. Mallett to then be able to obtain and disclose those medical records, which is why she was named on it, and which is why the release also went on to say, I understand that any disclosure carries with it the potential for redisclosure by the recipient of the information, and such redisclosure may not be protected by federal confidentiality law. That's the reason all of that language is in there, is because it allowed for Dr. Mallett to do those things. So for those reasons, we believe that this case was not properly dismissed, and we'd ask that the rulings be reversed so that we can have a trial on the merits on this case. Thank you.
Thank you. We will hear from the appellate.
May it please the court. My name is Natalie Bursai. I'm an attorney with Lewis Thomason and a member of the Memphis Bar. I'm here today representing the defendants, Dr. Veronica Mallett and UT Medical Group, in this matter. This case is before this court based on the trial court's grant of a motion to dismiss Dr. Mallett due to the plaintiff's failure to substantially comply with the pre-suit notice requirements of Tennessee Code Annotated 29-26-121. The matter is also before the court based on the trial court's grant of summary judgment to UTMG due to the plaintiff's failure to comply with the statute of limitations. The facts and the arguments related to these two motions are very different, so we filed separate briefs as to each defendant, and I plan to address the arguments as to each separately. Unless the court has a preference, I'll address UTMG's motion first. The argument, thank you, Your Honor. The argument in UTMG's motion is related to the first filing of this lawsuit. In the refile action, the trial court granted summary judgment to UTMG due to the plaintiff's failure to comply with the statute of limitations in the original filing. We submit that the trial court properly granted summary judgment to UTMG due to this failure to comply with the statute of limitations. The facts related to UTMG's motion all occurred related to that original filing of the lawsuit. The original lawsuit was filed on August 7th of 2009 against Dr. Mallett, Dr. Catherine Providence, and the chief administrator of the Med. UTMG was not named in the original filing, and the plaintiff alleged negligence related to a vaginal vault suspension and a hysterectomy performed by Dr. Mallett and by Dr. Providence, which occurred on May 7th of 2008. On June 2nd of 2010, the plaintiff filed an amended complaint naming UTMG as a defendant for the first time and alleging that UTMG employed Dr. Mallett and Dr. Providence. The plaintiff did so without seeking leave of court, without complying with Rule 15 of the Tennessee Rules of Civil Procedure, and without obtaining consent of the parties. This filing
litigated at the time.
We filed a motion to dismiss at that time. UTMG filed a motion to dismiss at that time, asserting violation of Rule 15. And that motion ultimately ended up being heard after the deposition of the plaintiff, Your Honor. So the motion to dismiss, though, was asserted very soon after the filing of the amended complaint.
And what happened as a result of that motion?
The court ultimately denied that motion and entered an order denying that motion. The trial court in the refiled action thought the order was a little bit unclear as to what the ruling was, but an order was entered denying that motion.
Was there more than one ground asserted in that motion, or was that the only ground?
Can you repeat that question, Your Honor?
Was there more than one ground asserted in the motion to dismiss, or was the improper joining of UTMG the only ground raised at that time?
The motion was initially filed based on Rule 15, and then once the deposition of Ms. Lott took place, the parties argued about the discovery rule.
Okay, so it was just a blanket dismissal then, is what you're saying?
We requested a blanket dismissal. And that was because the filing adding UTMG was over 2 years after the date of the alleged negligence and over a year after the expiration of the statute of limitations. We believe that the trial court in the refiled action correctly granted summary judgment, correctly found that the plaintiff had either actual or constructive knowledge of UTMG's identity as Dr. Mallett's employer over a year before the filing of the amended complaint, and correctly found that the discovery rule did not render the lawsuit to be timely filed against UTMG. Under the discovery rule, the statute of limitations in a medical malpractice case begins to run when the plaintiff discovers or reasonably should have discovered the occasion, manner, and means by which the breach of duty that caused injuries occurred, and the identity of the person who caused the injury. This is told only when a plaintiff has neither actual nor constructive knowledge of the injury, the wrongful conduct causing the injury, and the identity of the parties who engaged in the wrongful conduct. It's our position that Ms. Lott had actual knowledge of UTMG's identity before filing the original lawsuit. She signed 2 consent forms before the procedure at issue, and the one related to the surgery at issue includes a heading stating, "Who are my doctors and other healthcare providers?" It states, "I understand that the doctors and some other healthcare providers who provide care and services to me are not employees or agents of the Med. They practice their professions on behalf of themselves and or groups or corporations unrelated to the Med, including University Physicians Group, aka UTMG, or the University of Tennessee Medical Group and the University of Tennessee." Additionally, Ms. Lott was deposed during the first lawsuit. When asked who her OBGYN was in 2007 and 2008, she responded that it was UT Medical Group. She explained that she was first seen by a physician with UTMG before the year 2002, and that she'd seen a number of different physicians at their Midtown location. She testified that if someone had asked her who her OBGYN was from 2000 through 2008, she would have said UTMG. Before her surgery performed by Dr. Mallett, Ms. Lott testified that Dr. Providence had been her physician with UTMG and her contact there, and that Dr. Providence told her Dr. Mallett was going to be involved in the surgery. She also testified that after that May 2008 surgery, she went back to see Dr. Mallett at UTMG a number of times, and that after her surgery, she continued to be treated at UTMG, and she acknowledged that the physicians she saw there were in the same group as Dr. Mallett. Now, the discovery rule doesn't necessarily delay the accrual of a cause of action until the plaintiff actually knows a defendant's identity, but when the plaintiff reasonably should have discovered critical facts, including the defendant's identity. Plaintiffs have a duty to investigate and discover pertinent facts through reasonable care and diligence. We've cited in our briefing the Grindstaff case. It dealt with an issue where a plaintiff had knowledge that an employee was acting within the scope of employment at the time of a car accident after a plaintiff tried to amend a complaint to add an employer 28 months after the accident. And in finding that the employer should be dismissed, the court recognized that a modicum of investigative effort by the plaintiffs would have revealed the employment status of that driver and the potential liability of the employer. Here, at the very least, a modicum of investigative effort on the part of Ms. Lott would have revealed UTMG's status as the employer of Dr. Mallett. UTMG met its burden under summary judgment by citing to the consent forms and to Ms. Lott's deposition, showing that no material fact issues exist as to whether Ms. Lott knew or should have known of the identity of UTMG. So then the burden shifted to Ms. Lott to show that there was a genuine dispute for trial. And the plaintiff has pointed to no facts indicating that she's complied with that duty to investigate and discover facts about Dr. Mallett's employment status. Plaintiff has argued that she was unable to discover who employed Dr. Mallett until she received a complete set of medical records from the Regional Medical Center, which would have been in 2009 or in 2010. And Tennessee law that we've cited in our briefing stands for the proposition that the later discovery of additional facts of negligence doesn't toll the statute of limitations once the discovery rule is initially satisfied. Additionally, there's no separate independent cause of action for an alteration of an informed consent form. The original complaint actually already includes a claim for informed consent. So this receipt of medical records doesn't create some new cause of action that the plaintiff was not previously aware about. Also, to the extent that plaintiff is arguing that UTMG had withheld a consent form or any records, I would note that the records received by the plaintiff were from the Regional Medical Center, the Med, and they were not from UTMG. There's actually part of the record, an affidavit of plaintiff's prior counsel, Paul Springer, where he says that the records that they received later were from the Med. So the UTMG did not have anything to do with producing those records. The plaintiff has also argued that res judicata has barred defendants from even presenting this argument about the statute of limitations in the refiled action. As a threshold matter, the briefing merely sets forth the elements of res judicata, but doesn't demonstrate how they would apply to the facts of this case. It's a doctrine that bars a second suit between the same parties with respect to all issues that could have been litigated in a former suit. The Court of Appeals has recognized that where there's any question about whether it applies, it shouldn't apply. And the Supreme Court has acknowledged in the context of res judicata that the denial of a motion to dismiss does not end a lawsuit or constitute a final judgment, that it only applies if a prior judgment concludes the rights of all the parties on the merits. We know that the case wasn't concluded on the merits because the plaintiff has refiled it, presumably relying on the saving statute. I understand that plaintiff is arguing that the ruling is final, essentially because UTMG didn't appeal the ruling once the order of dismissal without prejudice was entered. It's our position that at that time, the lawsuit was not justiciable. It no longer existed between the parties. And so to require a prevailing party to appeal a decision when a lawsuit has been dismissed, I do believe would be a waste of judicial resources. Judge Corbin Johnson considered a number of issues when she was determining whether she should consider the statute of limitation arguments of UTMG. And they're all throughout the hearing in volume 6, the hearing that occurred on September 26th. She noted that she thought that the order was a little bit unclear and that she felt like she needed to decide the issue in the refiled action. She felt as though there may be more harm caused in allowing the case to move forward than considering the issue if it was something that could conclude the case. And she did note that it didn't appear to her in the order that what the judge actually considered was included, and that the judge previously didn't necessarily say it was an issue for the jury. It's our position that the amended complaint was filed outside that 1-year statute of limitations with no permission from the court, no compliance with the rules of civil procedure. It was filed over a year after Ms. Lott knew or reasonably should have known the identity of UTMG as Dr. Mallett's employer. So we request that the court affirm the grant of summary judgment to UTMG. If the court doesn't have any questions about UTMG's motion, I'll turn to Dr. Mallett's motion. The issue before the court as to Dr. Mallett is whether the trial court properly granted her motion to dismiss pursuant to the pre-suit notice statute, Tennessee Code annotated 2926-121, based on the finding that the pre-suit notice sent to Dr. Mallett did not include an authorization that allowed her to obtain health information from co-defendant UTMG and did not allow her to obtain complete medical records from each other provider receiving a notice. The healthcare liability statute requires, it's section A2E, requires each healthcare provider who will be a named defendant to receive a HIPAA compliant medical authorization permitting the provider receiving the notice to obtain complete medical records from each other provider receiving notice. There were 3 authorizations sent with the notice letter to Dr. Mallett in the refiled action. The authorization at issue in this case, which the plaintiff contends allows the release of records to Dr. Mallett, actually includes language that says, I authorize the University of Tennessee Medical Group to disclose my to obtain/request copies of my health information from the University of Tennessee Medical Group. I believe Mr. Tootin said in his argument that there was language, that language was more related to the purpose of the disclosure, but almost immediately under that language, the purpose of the disclosure is outlined. The language that we've cited is the only language actually authorizing someone to obtain and request health information, and that's University of Tennessee Medical Group from University of Tennessee Medical Group. This, the standard outlined in the Stevens case says that plaintiffs must substantially comply with section A2E of the pre-suit notice statute. And when prejudice results from the failure to comply, that's when substantial compliance is not achieved. And prejudice results when a party is unable to obtain medical records. And in this case, Dr. Mallett could not have obtained medical records. The issue of whether Dr. Mallett ever had medical records or whether it were in the previous filing, it's unrelated to the court's analysis in this case. In support of that argument, plaintiff has not cited any Tennessee law, but we've cited to the case of Foster versus Childs that found that pre-suit notice must be provided each time a complaint is filed. And in reaching this conclusion, the court recognized that at the time of dismissal of a first lawsuit, there's no pending litigation between parties, and that a second lawsuit is a new independent action. Based on these reasons, we would request that the court affirm the decision of the trial court finding that the plaintiff failed to substantially comply with the notice statute as to Dr. Mallett.
Okay, thank you.
Thank you.
Tootin, I believe you got 3 minutes.
Yes, and I'll address this, just get right to it. So it's even clear based on opposing counsel's argument as it relates to UTMG Medical Group, even when the trial counsel in the trial court in this matter granted their motion, it was not based on the fact that the amended complaint was not properly before the court, which is clearly proof, as I've already argued, and it's clear in the order. I don't believe that order was confusing or unclear. It attached a transcript with it. I believe when this court reviews the order, they will find that order was not unclear as well. But it will be clear from that the trial court did grant permission for that amended complaint to go forward. And opposing counsel was clear. That's why the heart of their argument was at the time the amended complaint was filed, it was after 1 year. But the amended complaint was properly before the court. And again, I think the order spells that out. And I think even the trial court's ruling, as now clarified even by opposing counsel, did not say otherwise as it relates to that issue. Secondly, I'll point out, as it relates to this statute of limitation, and it seems that opposing counsel keeps making this argument about how I'm somehow trying to create some new cause of action as it relates to some altered informed consent. And so I'll just rely on the law that already exists and tell the court, when you're talking about each cause of action, there's a discovery rule as it relates to each cause of action. And I want to clearly, and it's in my reply brief, my reply to the response, when it says misrepresentation, inadequate disclosure, here's the next keyword, forgery, or lack of capacity. When that happens, a claim for medical battery is stated. So saying that an informed consent document is altered and that's just me trying to create some new law when we find out about it later. No, there's a law that already exists. It's called medical battery. And when that is one of the grounds, a forgery to the informed consent form is done, then that's where that cause of action can raise. So no, I'm not trying to create a new cause of action. I'm simply relying on the case law that already exists. And then this argument about Dr. Mallett not being able to receive the medical release and do anything with it, opposing counsel conveniently keeps ignoring the fact that on the face of the document, Dr. Mallett's name and address is included. And when you look at the totality of the document and all that it authorizes, it clearly authorizes her to receive, obtain, and disclose those medical records. Opposing counsel does not seem to even offer a suggestion as to why her name and address would be included on a medical release form. Instead, opposing counsel ignores that. It just focuses on parts where she's not referenced. And I think that's a disingenuous argument at best. But when you see that she's named on the medical release form, being authorized to get this information from UTMG, logically, you have to ask yourself, what could that possibly mean? Why would she possibly be named on this document? And again, so for those reasons, we ask that the ruling of the trial court be reversed.
Thank you, counsel. We appreciate your argument. We will take this matter under advisement and attempt to get an opinion filed at the earliest possible time. Again, we appreciate you participating via Zoom. Ms. Angie, if you would, please recess court to the next case, please.
This honorable court is in recess until 10 a.m.
Thank you.